Hello, it's Philip Taylor speaking from Richmond Green Chambers in London. Today I'm doing a review of an article I've written for the Barrister magazine for Hilary Term 2020. It's an important article in my view. This is the Barrister magazine. It's the current one as I record this in January, in fact in early February now, 2020. My article appears on page 8. And it's an interview with Geoffrey Cox, and you can see a picture of Geoffrey there. I was very lucky and fortunate to be able to interview Geoffrey as the Attorney General. As I record this, he's been Attorney General now for quite a while, and during that time, of course, he's been overseeing as the legal advisor to the government Brexit, as a person who supported Brexit. Now, the title of the review I've given this article is Serving the Rule of Law Today, and it's an interview with the Attorney General, the Right Honourable Geoffrey Cox, Queen's Counsel, Member of Parliament. And I've given it some quotes at the beginning because I recorded well, actually not recorded, but I actually conducted the interview in the autumn, and it's taken a little while to appear, as is always the case in these longer term, more detailed, reflective pieces. But I've given it a quote from Thomas Paine in 1776, where I said, "These are the times that try men's souls," and the opening words of the series of pamphlets on the American crisis. Now, I say that, remember it's 1776, I say that for one reason. You can see the quote there, and that is that when I actually interviewed Geoffrey, we had a massive demonstration in Westminster Square by the Extinction Rebellion people. More about that now, because I'd like to just pay tribute immediately to Geoffrey and say thank you very much again for doing the interview. He did actually check it all over to make sure the quotes were right, and I'm very grateful for that, and also for the time he gave me. And this is what the article says. This is for people who probably won't be able to read the article and would like to hear it or see the presentation. It was all rather ironic, really. Fighting through the massed ranks of Extinction Rebellion, XR, in the autumn of 2019 to attend an interview with the Attorney General for the Barrister magazine. Those words of Thomas Paine came floating back to me as I crisscrossed Westminster through all of the huge number of people to get to my destination, which was the office of the Right Honourable Geoffrey Cox, Queen's Counsel MP. And as I say, it was a real tussle because the place was absolutely packed out with the demonstrators. The journey was trying, but nothing like the current political dilemma of our time, leading as it has to the Christmas Brexit general election on the 12th of December 2019. And I'm already using tags. I'm calling it the Brexit general election. And I will add here that when this was written, we didn't know the outcome of the general election, but we now do. Geoffrey is still the Attorney General, and Boris, of course, got a substantial majority in the House of Commons to deal with Brexit, get Brexit done, which was the slogan, and of course move on to other things. And I'm not talking about any of that stuff really, because Brexit is not a subject I'm interested in particularly, as I'm still remain a Remainer, although I'm not a Remoaner, and I've recognised reality when it stares me in the face. So, who is the current Attorney General as at February 2020? Well, one Geoffrey Cox, QCMP, an experienced leading counsel and known Brexiteer. And from English history, the first identified holder of the office of attorney was William de Bonville from around 1277 to 1278, but it's almost certain that there were previous professional attorneys or equivalents hired to represent the King's interests in court from around 1243 onwards, but they remain unrecorded. And I say that because clearly any form of when you go back in history, I'm not going to have the details anymore, but it would be very clear that the king, the monarch, would have had someone who was his legal advisor, not just for general stuff concerning affairs of state, but everything. And it's obviously rather different today because of the nature of our democratic government. Today's attorney, of course, is one of the law officers of the Crown, with a deputy who is known as the Solicitor General. It's currently Michael Ellis, MP. The attorney is a practicing barrister and an MP who serves as the chief legal advisor to the Crown and to the government in England and Wales. And he's also the head of the English Bar, presiding over our annual meetings. And again, quite often, very few people actually attend these meetings. I've been to a few of them. They're very interesting, but they're probably for the few rather than the larger numbers because of the amount of information that's being discussed at these AGMs. And of course, it's actually quite clearly very much directly linked to the Bar Council and the work that they do. Now, we started our conversation with his role as the head of the bar, and I asked about newly qualified barristers post-pupillage. Quote, "The state of the young bar causes me great concern," says Geoffrey. "I'm determined to do something about fees." And he highlighted this view to me. "I have secured the largest single settlement for the bar than any other department." Now, the comment, of course, came in response to my mention of what was known at the time as the extra Gawk money announced for younger counsel during a speech by the then Lord Chancellor David Gawk at the 2018 Bar Conference, which I attended. And of course this is specific for the criminal bar. Now, Mr. Gawk has gone. Obviously there are a lot of changes that have taken place, and at the moment there is going to be a Criminal Justice Royal Commission, and the money still remains a big issue, but there are clearly going to be changes as we now look to the new domestic agenda post-Brexit. At least I'd like to think that. Unfortunately, of course, there's no more money for the time being, I say in the article. So the problems of the young bar will persist, but better settlements are being achieved by the attorney. And that really is the answer to that particular question. Because our legal fees for public work are always a Treasury matter, of course. And I felt Geoffrey would push our case for extra money very hard as the head of the bar. It's a position he clearly relishes and treats with great importance and respect, as are his relations with the Bar Council. Sadly, of course, the problem remains that both the type of work and the money issues present problems for new barristers just starting out as the profession changes in the 2020s. And I'm a little biased. I like Geoffrey enormously. He was really quite clear and quite open about where he was coming from, and I actually think he will do the very best he can for us, and certainly he has done during his time as Attorney General. The background, of course, of the current attorney is very much that of a common law barrister from a military family. And Geoffrey has been involved in many high-profile cases in both civil and criminal jurisdictions. And to some, he was a surprise choice as attorney in 2018, possibly because of his substantial legal practice, which was, I think, rather unkindly over-commented on at the time. And to others, it was a logical promotion for one who, so immersed in the law, was to be given the chance to face an intimidating Commons Brexit chamber rather than the quieter courtroom, which is far less noisy generally, unquote. And that I'll come on to, because I believe that's an important point to bear in mind. The last Parliament we had was very different from what we've now got in 2020. Now, I've given us another sort of heading here, lenient sentences, because as I record this, there are plans afoot for emergency legislation concerning sentencing. So grossly or unduly lenient sentences have emerged as one of the developing issues of significance for the Attorney General's office. There have been considerable success in appealing low sentencing tariffs recently, and however, of course, the role of and appointments to the Sentencing Council remain controversial. The main issue, who appoints them, these policymakers, and do we have coherent representative involvement, remain unanswered. So there were no real answers to be found on this question when I interviewed him, but it's clear now from after the interview and the general election that this is an issue which is going to dominate the early part of 2020, bearing in mind what has been happening recently with terrorist outrages. And another probable area for reform arose when we moved to victim impact statements. Now, initially, I and others had not really favoured these statements because we're rather old school counsel. Geoffrey, however, described the statements as, quote, a move towards giving a voice to those who would not be heard, which means that there would be, quote, no harm in a judge understanding other views. And he made the sale with me on that point because I had some misgivings because of the way I perceive the criminal justice process, but I can see the need for that. And actually, in many ways, it's what we would call open justice in that sense, which is very much the policy the judiciary are pursuing, both in the civil and the criminal courts. Now, we come on to the controversial areas, the dead parliament. What's in a name? Now, we had a problem about this because historians commonly tag certain major events with nicknames. It's so useful, of course, for journalists, including myself. During the times we live through, such tags are not used, but they tend to appear later on. Such would seem to be so with the descriptions of parliaments and certain statutes which are supplied with nicknames. So we have the Ben Act, sometimes emotionally called the Surrender Act. All of this probably is now in the past. You've forgotten all about it, even in a few months, but we had all of that in 2019. Then there are other words which cause parliamentary outcry. At the end of this parliament, dead seem to have stuck, but Surrender Act has yielded to the Ben Act. Now, I don't know what history is going to talk of in about 2019, because 2020 was clearly the beginning of a new decade and a new government, because Boris has achieved a substantial majority, so much of the disputatious problems that we had seem to have gone because others will come along. Now, Geoffrey described that parliament as a dead parliament on various occasions during what was a particularly heated session in the Commons, which I watched prior to the interview. Actually, many agreed with him. Now, he said it is the noise which does not come across on the television, Geoffrey declared, as the shouting is filtered by the broadcasters and we don't hear the full horror of it all. A colleague, Sir David Livington, who's now retired, has described the process as gladiatorial. The political danger, Geoffrey said, over the challenging behaviour is the danger of losing the respect of the public. Another most practical observation from the bear pit, which is quite different from the courtesy of court. We certainly don't have anything like that. I practice mainly in the civil courts now, and we certainly don't have anything like that. There'll be occasional, very substantial problems I have in family matters and so on, and some civil matters, but nothing like the bear pit of the House of Commons. So we moved on to a comparison of the televising of Parliament with the courts. The Supreme Court, of course, established as a televised court. And since I wrote the article, the Court of Appeal is actually going to have some limited cameras in it to, and the Crown Court, of course, to record sentencing, only fixed on the judge, as they do in Scotland, but that is a step forward. And of course, what we've got with the establishment of the Supreme Court as a televised court is, that's a phone, forget about that. Geoffrey's view, though, after the latest skirmish with a hostile Commons atmosphere, was some guarded support for limited court hearings, but not trials to be televised. Although he said we should be careful over the cases which would be heard on television. Now, what we've got since then, now that the interference from the telephone has gone, is that the limited court hearings are going to be in the Crown Court, and it will be sentencing. And of course, it's just a very, very ginger step forward. It's going to mean some more legislation, but we are moving ahead. And I think, judging by what we've seen, this is again part of the open justice concept. Now, I liked Geoffrey's approach throughout, which is always practical, passing what I call the reality test we use in mediation. Quote, "I have profound admiration for those doing something I cannot do," he said, although he remains, of course, one of the giants of the contemporary bar, and always a consistent approach has been adopted by him towards the client, especially in this case, as it happens to be the government. I then asked another question. Taking silk, was it a risk? I asked. Not really, as it never seemed in doubt. Silk was a progression from undergraduate law and classics studies at Downing, Cambridge, to international outside work, whilst an MP, and that was a backbench MP, which has been so unfairly criticised, in my view, by some who don't seem to understand the need for outside experience brought to the Commons. Now, such a question would never need to receive an answer for Geoffrey, who, to many, is the epitome of leading counsel. Great voice, sharp mind, attention to detail, and humorous in much the same way as we sometimes are in the robing room. And I say that because obviously I'm part of the profession, and a lot of people, very few people really know what we do as barristers. When they do come to see us, it's normally in a very strained, very emotional, very, very edgy occasion for everyone concerned. So it is understandable, but as I say, public legal education is very much where we're moving towards, I think, in the 2020s. Now, Geoffrey concluded this section of the interview reminding us that support for the rule of law and not the pursuit of violence is the foundation of democracy, and I believe that's a very important point to stress because it's a main policy point. Let me talk then about advocacy. I've given this heading, Modern Advocacy, Be Succinct, Clear and Fair. Now, Heather Hallett summed up the modern approach to advocacy in this way: be succinct, clear and fair. She explained that she appeared before a Court of Appeal judge who, quote, "I thought behaved so rudely to me that I went out and phoned the Bar Council and asked if I had to put up with this or with it." For many readers, the answer is a clear yes. It's the same in the Commons. And whilst Heather's superb, I mean, you can understand how she'd have felt. And there have been occasions where I know a lot of other people have felt exactly the same way. Why don't I have to put up with this? But I'm afraid you do. It's rather like being in the army. I'm afraid you have to put up with it. You can complain to a certain extent, but you basically have to put up with it. So let's talk about the Commons. Times change, as Geoffrey found out, with the torrent of criticism for the use of the standard form question counsel traditionally asks as an advocacy device. When did you stop beating your wife? This caused uproar, and the uproar and the aftermath probably illustrate to practitioners like me and many of my colleagues both a change in the style of modern advocacy and the need for better education of what we do whilst wearing our wigs and gowns. Now, I say that because I do think that this is an area we have to concentrate on in this decade. Geoffrey reiterated, and I want to say this, that his position by saying, "I apologise again for any offence the comment caused," and he went on, "I believe domestic abuse to be one of the most heinous crimes affecting our society, and I did not intend to trivialise the issue." Now, I understand his position, and that I had to ask that question of him because clearly it is a problem. And of course it gets to the issue of advocacy because it led nicely to the question about PLE, public legal education, which I'm very much a supporter of. And it plays, quote, "an absolutely crucial role to cover advocacy in the growing public lack of awareness in the way the legal system works." Geoffrey is very much the leading officer who serves the rule of law with the Lord Chancellor Robert Buckland, acknowledging that we have one of the finest judiciaries in the world. Well, I think we have the best in the world, and of course I think the common law is the best system, and our rule of law is the best also in the world. Now we moved on to talk of famous past advocates, Marshall Hall, Burkitt, and to contemporaries such as Tony Scrivener, Gilbert Gray and George Carman. The trick remains that advocacy only succeeds when it focuses on the argument, to go with much of what Heather suggests. And of course there have been suggestions about the types of question that you ask, but I actually believe that advocacy, you can teach a certain amount, but you just have that innate skill sometimes to be able to get the information out. By the way, you don't do it the way the interviewers on television do it at all. You ask slowly and build it up. But of course on television they haven't got time for that. They've got to get the little slice in very quickly. It's rather different for us. Now, explaining judicial precedent, that was another area I wanted to talk about with the Attorney General. There seemed little point in asking the Attorney for his view on the Supreme Court ruling on prorogation of Parliament, which all seems such a long time ago now, and all the issues that surrounded it at the time, mainly because the answer would have been obvious from Geoffrey. However, what I did was the professional interest always lies with the earlier judgment of the Court of Appeal, where the Lord Chief Justice, the Master of the Rolls, and the President of the Queen's Bench Division of the High Court backed the government, which of course I did. The question, and Geoffrey of course was delighted, the question posed then, has the Supreme Court become political, as many Tory activists suggest? And does the suggestion dissenting judgments of today make good law tomorrow really apply? Now, I wrote that at the time, and politics can change very quickly, as it has done, because what I wrote there was about whether we would be looking at vetting people on the Supreme Court. Now, the Lord Newburgh, who I'd met, said, quote, bonkers to that suggestion. However, it seems to have come back again. But I suspect one will find the House of Commons will not go down that route, because it's a dangerous route to go down. However, we have to wait and see, because as I said, I wrote this in at the end of 2019, and things have changed quite quickly. But no reaction actually came from the Attorney General to either suggestion that our justices are political or dissenters, even though we do have an evolving constitution, which of course causes a re-examination of constitutional matters from time to time. And that was about as far as I could take it. But since then, we know that the government, the new Johnson government, is going to be looking again at this area. So I'm sure that there will be some changes that take place. Nevertheless, the attorney showed some concern over how judicial precedent works, because it's become apparent that how our system of precedent works is largely misunderstood by the public. Reaction, for instance, to Lady Hale's judgment against Boris produced some surprising results, the favourite being a complete ignorance of the court structures and how a finding in one court can be changed by another. And I've got another case, even now as I speak, where exactly the same thing is happening. There's a complete misunderstanding, sometimes by professionals who are too close to a subject, that they have misunderstood the way that the process operates. And of course, the first appeal, which the government won, was discounted and ignored once the Supreme Court ruled the other way. And a great pity, some may say. So the Speaker's Education Unit and the concept of public legal education still, in my view, have a lot of work to do. And of course, whilst John Bercow has gone as the Speaker, the Education Unit under Sir Lindsay Hoyle is still there, and I'm sure it will do an excellent job. And whilst I know it's not probably good to mention John Bercow too much, I would like to say that I think that was a very helpful move forward. And I say that because obviously I've known John Bercow for quite a long time. And it's got nothing to do with anything other than I think that was a very good initiative. And I was reminded here of H.L. Mencken's words. Democracy is the theory that the common people know what they want and deserve to get it good and hard. Thinking about the general election which is underway as I wrote the article, which way will they go? Now, the workings of Parliament will have come under intense scrutiny at that particular time, and that now that we have a firm, clear government with a proper majority, things will change. But we're just now looking at that as a piece of history, because when Geoffrey expressed the view that there is a political danger of losing the respect of the public over recent events, he summed up a prevailing mood which has, with great respect, almost evaporated in very, very quick time. The purpose, he said, should be to maintain the assent of the public, although events could prove otherwise at the turn of the year. Well, what's now happened, of course, is we've had a clear mandate for a new government, and so much of the past bickering has now become history. Let's talk about something else that I thought would be fascinating, trilaterals. I do hold trilateral meetings with both the Home Secretary and the Justice Secretary regularly, said Geoffrey. A welcome move forward as a whole system approach, which he's adopting, which looks to expand in the next Parliament. And I think there's quite a lot of that taking place, because when you look at a number of government ministers at the more junior levels, they are actually crossing more than one government department. We are expecting, of course, a major reshuffle in February 2020, but at the moment, certainly this concept of one department speaking to another and having bilateral and trilateral meetings is obviously very much to be welcomed. And it's been something that's been on the political agenda certainly for the last 30 years. Now, for years, of course, the criticism has existed that cabinet ministers have become too territorial, probably because of the public spending reviews. That's obviously got something to do with it, because their civil servants going, well, your job, Minister, is to go in there and get us the money. Remember, yes, Minister, very true point. That is what the job is, get as much money as you can so that we can spend it in our department. And you can see that means that someone else is going to lose if you get more of the part of the money. Now, you can see that from that, the problem is it does become too territorial, and so these bilaterals and trilaterals provide useful cross-departmental conversations to exchange information. More reality and practicality on display, in my view, because this actually is the way forward to many people, including, in my view, myself. I think that is the way that we should be going. Let's talk about the constituency, because Devon, it's a Devon constituency, and Geoffrey first stood for office in the year 2000. It's actually the Torridge and West Devon Conservatives organisation, association, in the constituency, which was formed actually in 1983. And he was finally elected in 2005. Remember, at that time there was a Labour government, and he increased his majority on each occasion that he stood since. And the current 2017 majority was 20,686, so it was a 74% turnout, which placed the Labour cooperative candidate second, supplanting the Lib Dems, with no UKIP candidate in sight. And, quote, the buzz of elation on winning an election which one feels can be like final speeches. Yes and no, he says, but the adrenaline certainly does flow. I know that because I've won and lost. Geoffrey's won and lost. And of course he did very well excuse me, in the 2019 election. I haven't got the election results for that, but clearly this is the article before that election took place. And of course it's a beautiful West Country constituency which stretches from Lundy Island in the north and a Westward Ho, that's the town with white houses, Bideford, and of course down to the fringes of Dartmoor in the south, presenting a rather elongated slice of western Devon for the candidates to actually pound the streets and the country roads. And of course local issues are dominated by agriculture, food processing, defence, fishing and seasonal tourism. So there's a mixture of towns and rural communities to represent. And quite often, having myself fought a number of elections, you do have the mixture of the town and gown, both in Oxford, where I was elected as a councillor, and in Richmond, which is much more city orientated. But we have the same issues. It doesn't really matter. Even if it's a wealthy, leafy area like Richmond, you've still got the problems of poverty, you've still got the main issues. It's exactly the same actually abroad. When I've been abroad in other countries, they call them by different names, but the same issues are there in slightly different ways. Now, the end note, let me talk about to lift a curse. Just a bit of lightness to the end of the article. Interviews with these important office holders that I've conducted end with my standard question asking, what is the most popular issue which arises in the local MP's postbag or mailbox? It's normal for the usual suspects to appear. For instance, it would be agriculture, lack of broadband in rural areas and specific constituency-centric controversies, and of course the dreaded Brexit. Of course, jovial Geoffrey had other ideas, and he ended with a short tale of a constituent who turned up asking him, quote, to lift a curse which has been placed on me. Possibly a bit stumped.